Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third-party books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case State ex rel. Fockler v. Husted, 150 Ohio ST 3D 422, Ohio, Supreme Court, 2017. Friends, guess which party we're going to talk about today? Guess. It's a party I voted for before. The party of which I speak is, drum roll please, the Libertarian Party. This involved Gary Johnson, and we also have talked about Gary Johnson before on a prior podcast or two, at least once. So friends, let's talk about what happened here. It says, quote, relators John Fockler, Kevin Neither, M. N. Leach, Scott Pettigrew, and Harold D. Thomas are the members of the committee that nominated Gary Johnson and William Weld to appear on Ohio's November 2016 ballot as independent candidates for President and Vice President of the United States. After Johnson and Weld jointly received 3.17% of the total votes cast in Ohio for President and Vice President, relators brought this mandamus action seeking to require respondent Ohio Secretary of State John Husted to recognize relators as a political party under RC 3517.01, end quote. First of all, since I hear a lot of libertarians talk about Gary Johnson sharing their opinions, what do you think about Gary Johnson, friends? What do you think? Specifically, they had an issue with that paragraph in general, so let's talk about specifically what happened. It says, quote, Gary Johnson and William Weld appeared on as independent presidential and vice president candidates on Ohio's November 2016 ballot. At that election, they received 3.1.7% of the vote. On December 2, 2016, relators submitted a letter to Husted requesting that he recognize them as a political party under RC 3517.01, parentheses A, parentheses 1, parentheses little a, because their candidates have received more than 3% of the vote at the November election. In the letter, they requested recognition with the party identification of Libertarian. They attached an additional letter from the Libertarian Party of Ohio joining the request and consenting to the relators' use of the Libertarian Party, and Libertarian Party of Ohio for the purpose of party recognition, end quote. So our friends did well at the election, as such goes. They got 3.17% of the vote. They ran as independents in the election. They had some valid reason to do that. It was part of their strategy. And then since they got enough votes, although they ran as independents initially, they wanted to become affiliated as a recognized political party in Ohio with the Libertarian Party. So friends, do you think they should have gotten that right? Unfortunately, the election officials didn't just give it to them. They challenged this, and hence we have this courtroom battle. So they talk about the various laws and how they affect such things, and how you can be recognized as a political party, and how our friends here use the independent route first. I've seen other cases where individuals would be independents in one state, but they would be affiliated with a party in another state, such as one case involving Ralph Nader, we talked about on this podcast, and one case involving Harry Brown. I did not see it in one state where they switched back and forth, depending on how it worked. Also, they got the support of a prominent third-party supporter in this trial. So let's read. It says, quote, as support for their position, relators cite an affidavit from Richard Winger, the editor of Ballot Access News, who purports to set forth the history of Ohio's ballot access laws. Wingers contends that going back to at least 1914, associations were statutorily permitted to gain ballot access based on the percentage of the vote received by their candidates, with the petition process for establishing new parties not enacted until 1929. Even if Winger's affidavit had been properly sworn, relators' reliance on it is misplaced. Based on the affidavit, relators contend that Ohio has continuously since 1914 permitted groups of voters to establish political parties by running independent candidates for office. But the statute that Winger cites as being continuously in effect was invalidated in 2006, Libertarian Party of Ohio versus Blackwell. Therefore, a vote percentage process for groups of voters to establish political parties has not been in continuous effect since 1914. End quote. So friends, this gets me to think. When we have our trials, which experts do we want to bring in to support us? Since they brought in Richard Winger, that's a person we could ask. Who else could we ask? Richard Winger might not be available. It might be a long time. So we got to think about other people. If we deem it appropriate in our cases to have an expert, which expert in the third party field could we ask for? Somebody that we would be able to get access to, yet someone who could also help our case. Richard Winger must know a lot, because I imagine it would be hard to track all the different states' ballot access laws. We've talked about many of those on this case, on this podcast. Therefore, it seems Richard Winger is wise because he can grasp all that knowledge and process all that knowledge, all those different states. So good job, Richard Winger. So ultimately, they concluded as follows. They say, quote, relators are unable to demonstrate that they are entitled to a writ of mandamus because they have failed to show that Husted either abused his discretion or acted in clear disregard of the applicable law. Husted correctly determined that in order for the Libertarian Party to regain ballot access, it must file a petition that meets the statutory requirements. RC 3501.01 and 3517.01 do not authorize the formation of a new or revived political party based on the percentage of the vote received by candidates who appear on the ballot as independents. Writ denied, end quote. Alas, we don't want to hear the words writ denied when our friends are applying for a writ. But we applaud Gary Johnson, William Weld, and the rest for doing what they need to do to get on the ballot. May this help us and may it inspire us. Long live third parties. Goodbye.